Hi, greetings, it's me, Dr. Paul Gerhardt, and this is the third video in my Human Resource Management video series. And this particular video is on providing equal opportunity employment and for safe workplaces. So these are some things for you to consider if you are either in the human resource field or thinking about getting in the human resource field. This is one of my most technical videos, and so pardon me while I read my notes to you, because there's a lot of specific things that you really should know as it relates to laws and regulations. And so in here I want to talk a little bit about the three branches in government and how they regulate human resource management. We're going to talk about the federal agencies and then enforcing equal opportunity employment. We're going to talk a little bit about sexual harassment and how employers can eliminate or minimize it. We're going to talk about occupational safety and the health acts, the rules of the Occupational Safety and Health Administration, and we're going to discuss ways that employers can promote safety and health. So it's going to be kind of a long video, so grab a tub of popcorn and a soda and just join me if you would, please. So let's talk about the regulation of HRM. There are three different branches. Of course, we know the legislative branch, the executive branch, and the judicial branch. The legislative branch has enacted a number of laws governing HR activities. The executive branch is responsible for enforcing the laws, and they include regulatory agencies that the president oversees. And then there's the judicial branch, which interprets the laws, and the Supreme Court is the court of final appeal. And its decisions, of course, are binding, as many of you know. So, equal employment opportunity, the EEO. This is the condition in which all individuals have an equal chance for employment regardless of their race, color, religion, sex, age, disability, or national origin. The federal government's efforts in this area include constitutional amendments, legislation, executive orders, and court decisions. Now, the equal employment opportunity, the 13th Amendment abolished slavery in the United States, so an employer can't have slaves, and has been applied in cases where discrimination involved symbols or incidents of slavery, believe it or not. The 14th Amendment forbids states from taking life, liberty, or property without due process of law. That's the 14th Amendment. It prevents states from denying equal protection of discrimination, and it applies to decisions or actions of government or private groups whose activities are deemed government actions. So the equal employment opportunity also has the Civil Rights Act. This is from 1866 and 1871. And the Civil Rights Act of 1866 granted all persons same property rights as white citizens. And the Civil Rights Act of 1871 granted all citizens the right to sue the federal court if they feel that they have been deprived of some civil right. Now, the Equal Pay Act of 1963 says that men and women in an organization doing the same work must be paid equally. And equal is defined in terms of skill, effort, responsibility, and working conditions. The Title VII Civil Rights Act of 1964 prohibits employers from discriminating based on race, color, religion, sex, or national origin, and it applies to organizations that employ 15 people or more. Age discrimination, the Age Discrimination Employment Act, or the ADEA, prohibits discrimination against workers who are over the age of 40. And age discrimination complaints make up a large percentage of complaints filed with the EEOC. So, over the years, the rates of age discrimination complaints goes up to around 16,000 in 2001, all the way as high as about 25,000 complaints in 2008. And to this day, it's right just a little bit below the 20,000 mark. So age discrimination complaints make up a large percentage of the complaints filed to the Equal Employment Opportunity Commission. And whenever the economy is slow, the number of complaints grow. For example, the number of age discrimination cases jumped in 2008 when many firms were downsizing, and has fallen slightly as the recovery has proceeded at a slow pace. Another increase of age discrimination claims accompanied the economic slowdown in the beginning of the 2000s. So, in 1973, the Vocational Rehabilitation Act came about, and this covered organizations that must engage in affirmative action for individuals with disabilities. Employers are encouraged to recruit qualified individuals with disabilities and make reasonable accommodations for them. In 1974, the Vietnam-era Veterans Readjustment Act came about, which requires federal contractors and subcontractors to take affirmative action towards employing veterans of the Vietnam War. And it covers veterans who served between August 5th, 1964 and May 7th, 1975. Pregnancy Discrimination Act came around in 1978, and it defines discrimination on the basis of pregnancy, childbirth, or related form of medical condition to be a form of illegal sex discrimination. And benefits including health insurance should cover pregnancy and related medical conditions in the same way as medical conditions. The Americans with Disabilities Act, or the ADA of 1990, protects individuals with disabilities from being discriminated against in the workplace. It prohibits discrimination based on disability in all employment practices. Employers must take steps to accommodate individuals covered by the Act. The Civil Acts Right of 1991 adds compensatory and punitive damages in cases of discrimination under Title VII and the ADA. Amount of punitive damage is limited by the Act and depends on size of the organizations charged with discrimination. The Uniformed Services Rights Act, employers must reemploy workers who left jobs to fulfill military duties for up to 5 years, and they should be in the job they would have held if they had not left this for service in the military. So there are maximum punitive damages that are allowed under the Civil Acts Right of 1991. So it depends on employer size. So if the employer employs between 14 and 100 employees, then the damage limit is $50,000. If the employer is 101 to 200 employees, the damage is $100,000. If the employer is 201 to 500 employees, it's $200,000. And if it employs more than 500 employees, then the damage limit is $300,000. And so that's kind of important to know. Some genetic information, Non-Discrimination Act of 2008 is kind of interesting. And it says that employers may not use genetic information in making decisions related to terms, conditions, or privileges of employment. It includes a person's genetic test of a person's family members, and family medical histories. And it forbids unintentional collection of this data. And it forbids harassment of an employee because of genetic information. The Lilly Ledbetter Fair Pay Act of 2009 covers not being paid the same as one's coworkers where the difference is due to race, color, religion, sex, national origin, age, or disability. Okay. Here's more. The Executive Order 11246 prohibits federal contractors and subcontractors from discriminating based on race, color, religion, sex, and national origin. Employers whose contracts meet minimum size requirements must engage in affirmative action. Executive Order 11478 requires federal government to base all of its employment decisions on merit and fitness. And it also covers organizations doing at least $10,000 worth of business with the federal government, so subcontractors to the government, or contractors to the government. So government's role in providing for equal employment opportunity. The Equal Opportunity Employment Opportunity Commission, or the EEOC, is responsible for enforcing most of the EEO laws. They investigate and resolve complaints about discrimination. They gather information. They have issues and guidelines. They monitor the organization's hiring practices. Complaints with them must be filed within 180 days of the incident, and the EEOC has 60 days to investigate the complaint. So there are all sorts of types of charges filed with the EEOC, but the number one amount of charges really is about retaliation. Second most is race. Third most is disability. Fourth most is about sex. Fifth most is about age. And then the sixth most is about national origin. And then religion is way down on the list at seventh, and then color. So just to kind of give you an idea of what kind of cases that they're seeing. The government has a role in providing for the equal employment opportunity. And the Office of Federal Contract Compliance Procedures, or the OFCCP, they're responsible for enforcing executive orders that cover companies doing business with the federal government. They do audits for government contractors to ensure they are actively pursuing goals in their affirmative action plans, and the plan must include utilization, analysis goals, and timetables and action steps. So businesses have a role in providing for the EEO. Disparate treatment. This is the differing treatment of individuals based on the individual's race, color, religion, national origin, age, and disability status. And one of my favorites is the bona fide occupational qualification, or the BFOQ, which essentially says a necessary, not merely preferred qualification for performing a job. And the Supreme Court has ruled that BFOQs are limited to policies directly related to a worker's ability to do the job. So, disparate impact. This is a condition in which employment practices are seemingly natural, yet disproportionately exclude a protected group from employment opportunities. And then there's the 4/5 rule. This is a rule of thumb that finds evidence of discrimination if the organization's hiring rate for a minority group is less than 4/5 the hiring rate of the majority group. And comparing rates of hiring, not numbers of employees hired. All right. So, when you are providing reasonable accommodation as an employer, an employer is obligated to do something to enable an otherwise qualified person to perform a job. Companies should recognize needs based on individuals' religion or disabilities, and employers may need to make such accommodations as adjusting work schedules or dress codes, making the workplace more accessible, or restructuring jobs. So there's a lot of different things that employers could do. They can modify work schedules, they can modify exams of training programs, they can provide qualified readers or interpreters, they can acquire or modifying equipment, and making facilities accessible. So these are just a few things that you should consider. Preventing sexual harassment is a really big one. And sexual harassment really refers to any unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature when submission of such conduct is made explicitly or implicitly a term of condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as a basis for employment decisions affecting such an individual, or such conduct has the purpose of effect of reasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. So a lot of things covered there. So organizations can prevent sexual harassment by doing a few things. One, by developing and communicating a policy that defines and forbids it. Two, training employees to recognize and avoid this behavior. Three, providing a means for employees to complain and be protected. So, Occupational Safety and Health Act authorizes the federal government to establish and enforce occupational safety and health standards for all places of employment engaging in interstate commerce. It was established with OSHA, and it was responsible for inspecting employers for applying safety and health standards and levying fines for violations. So that's what OSHA is really all about. So it's the Occupational Safety and Health Act. General Duty Clause. Each employer has a general duty to furnish each employee a place of employment free from recognized hazards that are likely to cause death or serious physical harm. Specific duties. Employers must keep records of work-related injuries and illnesses. Employers must post an annual summary of these on record from February 1st to April 30 in the following year. So, according to the Occupational Safety and Health Act, employees have the right to 1. Request an inspection, 2. Have a representative present at an inspection, 3. Have dangerous substances identified, 4. Be promptly informed about exposure to hazards and be given access to accurate records regarding exposure, and 5. Have the employer violations posted at the work site. So kind of a lot of things to consider. Some of the top 10 causes in workplace injuries is something that's really interesting. The number 1 is overexertion. 2, falls. Struck by an object, bodily reaction, roadway incidents, slip and trip without fall, caught in or compressed by equipment, stuck against objects, and then the smallest one is repetitive motion. So employers need to understand how to reinforce safety practices. They need to do an analysis for job safety, and then they need to promote safety by determining which specific element of a job led to a past accident. So reinforcing safety practices requires implementing a safety incentive program to reward workers for their support of and commitment to safety goals, to start by focusing on monthly and quarterly goals, and encourage suggestions for improving safety. Promoting safety internally should consider cultural differences that may make it difficult, laws, enforcement practices, and political climates that vary from country to country, and companies may operate in countries where labor standards are far less strict than in the U.S. So I know that I've rambled on for a long time, over 20 minutes, about all of these equal opportunity and safe workplace things that human resource people should know. So I encourage you to revisit the video when you got an extra 20 minutes and consider, what are you doing to promote safety? What is your organization doing in adhering to equal opportunity laws? So thanks so much for your valuable time. I hope you've gotten something out of this video and that you've enjoyed it. And I hope that you have a great day, because only you get to choose how you feel about it. I'm Dr. Paul Gerhardt.